Hello and welcome to Introduction to Guardianship and Alternatives. My name is Jonathan Martinez with the National Resource Center for Supported Decision Making. In this session you'll learn about guardianship, what it is, what it isn't, and alternatives to it. And I think if we're going to understand what guardianship is now and in the future, we need to understand where we came from. So first things first about history. Guardianship started in ancient Rome about 2,000 years ago, where people called curators were appointed for people with disabilities to make decisions for them. But if you were just feeble-minded and not otherwise disabled, you could still enter into contracts for yourself. I guess that's a bit of good news. As Rome fell, the laws got harsher. In the 5th century, in the Dark Ages, the Visigothic Code said that people who were insane or had some need could not enter into contracts and could not testify and couldn't do a whole host of things as time went on. In feudal England, there were laws that divided people with disabilities into idiots and lunatics and appointed people over them to make decisions for them. All of this means that for 2,000 years, guardianship has taken away people's rights or taken away the right to make decisions from people and given it to someone else. And it's also from a time when it was okay to call people with disabilities or people with any kinds of limitations things like idiots and insane and feeble-minded. In America, guardianship is a state law issue, meaning that every state has its own guardianship law, policy, and practice. And you can see your state's guardianship law on this website in the link section called In Your State. But every state has a few things in common in their guardianship law. First and foremost, guardianship is a legal intervention. That means you're going to court, and the court is going to get involved in your life. It is the court's decision whether to appoint a guardian, and the court's decision who that guardian is going to be. It is the court that takes away the person's right to make decisions and gives it to someone else. And if the court does not like the way one guardian is doing his or her job, or disagrees with decisions made by the guardian, the court can take away the right of that guardian and appoint a new guardian. And in general, in every state, a guardian is appointed by a court if the court decides that the person is incapacitated or lacks capacity or somehow needs protection of someone making decisions for him or her. Guardians are often appointed in emergency situations when a person is physically incapacitated or is unable to communicate any decisions, and there's no one else out there who is able to work with that person to make decisions with him or her. But what I can tell you is that guardianship is not always needed. And there's certain times when I can tell you it's never needed. Guardianship is never needed just because that's the way it's always been, just because it's for the person's own good, or just because a person has a particular IQ or a particular diagnosis or a particular disability. What guardianship is individualized. It recognizes that every person has different abilities and every person has different limitations. So instead of a bright line test where we say guardianship is or isn't needed just because, you look at a particular person's abilities and a particular person's needs, and you decide if that person should have a guardian. Not whether people like that person have guardians or have ever gotten guardians, but whether that person in particular needs a guardian. And every state guardianship law is essentially the same. They all say that a guardian should be appointed if a person lacks capacity to make decisions and there are no less restrictive alternatives available other than guardianship. And again, I recommend you go look at your own state law in the In Your State section of this website. So let's break this down. First things first. First question, does the person have capacity to make decisions? Just about every state law uses that term, capacity, which means the ability to make or communicate decisions. And I can tell you what capacity is not. It's not IQ. It's not the just because things we talked about before. You should never say that just because a person has a particular IQ or a particular diagnosis that that person lacks capacity. It's not universal. You should not say because other people who have this person's particular IQ or diagnosis have guardians, this person should have a guardian. No, capacity is highly individualized because we look at each person and the way each person makes decisions. We all make decisions in different ways. What capacity is complicated. It's difficult to measure or assess because each one of us makes decisions in different ways. We may have capacity to make certain types of decisions, but not others. Some people may have never had true opportunity to make decisions, therefore it may look like they don't have capacity. And think about it. Are there decisions that you lack capacity to make or that you need help in making? I'll guarantee that every person listening to this session needs help in making at least some type of decision. So the question is, because you cannot do your taxes without assistance, do you lack capacity to make financial decisions? Or just because you need a second opinion to make a medical decision, do you lack capacity to make your own medical decisions? No, the answer, of course, is no. It just means that your way of making decisions is individualized to you. You make decisions the way that you make them, and each person does that as well. So when we look at whether a person has capacity to make decisions, you have to realize that people may have capacity to make some decisions, but not others. And that lacking the capacity to make one type of decision does not mean you lack the capacity to make all types of decisions. A person might be able to make decisions at some times, but not at others. A person may be unable to make some or all decisions unless they get help. And these are all things that should be considered when deciding if a person has capacity, because capacity is not measured in a vacuum. Because if it was, all of us would lack capacity because we all lack capacity to make certain types of decisions without assistance. So when measuring a person's capacity, think about that. When you're deciding or whether you're exploring whether a person has capacity, think about the person's opportunities to make decisions. Think about that person's history. Has the person made decisions before? What type of decisions? What type of help has the person gotten to make decisions? If you're concerned about the person's ability to make decisions, ask what help has ever been given to this person to make decisions? What services have been sought to make decisions? Because again, we cannot view capacity in a vacuum. Capacity is individualized to the person, and like everything about an individual person, that person's history matters. But even if a person lacks capacity, let's assume for a second the person you're working with doesn't have capacity to make decisions by him or herself. Before a guardian can be appointed, there's another question to be asked. What else have you tried other than guardianship? Because remember, it's a two-part question. Does the person have capacity? And are there less restrictive alternatives available other than guardianship? Because guardianship is only appropriate, even if a person lacks capacity. It's only appropriate if there are no other less restrictive alternatives available. A less restrictive alternative is just something that is less harsh or less restrictive or takes away less rights than a guardianship. And there are many types of less restrictive alternatives, some of which you'll find information about on this website, such as supported decision-making or powers of attorney, or even limited guardianships that only take away certain types of rights. There is supports and services like peer support and life coaching. There are financial supports like Special Needs Trust. There are legal supports like a Healthcare Decision Makers Act that gives a person the power to make medical decisions but no others for a person only in one type of situation. Let's look at just one example, like a power of attorney. Now remember what we said about a guardianship. It's a legal intervention. The person making the decision there is the court. The court is ultimately the guardian. The court appoints the guardian to make the decisions, but the court ultimately has the power to take away that and give that power to make decisions to someone else. A power of attorney, on the other hand, is a voluntary agreement by a person to say, I need help making a particular type of decision, or I want someone else to make a particular type of decision for me. And it gives the person the power to specify what person will make the decisions, what types of decisions will be made, when those decisions will be made, and how they will be made. So the person retains control to the maximum extent that that person wants and needs without the need for a court to be involved. Because that's what less restrictive options do. They respect and empower people to be their own decision maker to the maximum of their abilities. And they respect each person's decision-making voice, the particular way each person makes decisions, with or without support, when support is needed, how support is needed, and what types of decisions need support, as opposed to a guardianship which by and large takes away the right to make all decisions in a person's life. So before you invite the court into your life, or into the life of someone you care about, ask yourself those questions. Does a person really, really lack capacity? And if you think they do, what's been tried to increase that person's capacity? What's been tried to develop that person's capacity? What has been tried to support that person's capacity? And even if that person lacks capacity, are there really no less restrictive alternatives? What's been tried? What have you ruled out? What methods have not worked? Don't panic. That's the best advice I can give any family member who is considering a guardianship, or any friend, or anyone who's thinking that a person might need a guardianship. Don't panic. You're going to have people tell you that everyone with your friend or family member's condition, diagnosis, needs, gets a guardian. Not true. You're going to be told that guardianship is required to get particular types of services. It's not true. Do plan. There are opportunities all around us throughout our lives to help us develop and enhance our ability to make decisions. For children and teenagers, there's special education. For adults, there's vocational rehabilitation. There are adult services and Medicaid supports and services and Medicare and health care planning and financial services out there that can help us maximize the control we have over our lives. Because as you'll see on this website, the more control we have over our lives, the better our life outcomes are. Everyone needs some support. So ask. Everyone needs help in making the best possible decisions. So contact us. That's my name on this slide. That's my telephone number and my email address. Please feel free to contact me. And please join Supported Decision Making Interactive, our dedicated listserv, where you'll be able to connect with people facing situations just like you are, and ask questions and have them responded to by national experts so you can get the best possible information that you need to make the best possible decisions in your life. Thank you so much.